Welcome to Reducing Risk, a series of podcasts from Medical Protection created specifically for doctors in Aotearoa, New Zealand. Reducing Risk looks at key medico-legal issues in our jurisdiction and provides helpful advice and guidance on how to manage those risks. This current series focuses on privacy. My name's Dr. Sam King and I'm one of the medico-legal consultants with Medical Protection. And I am joined today by a couple of colleagues as well as a lawyer. Firstly, I'd like to introduce Mr. Joe Fitzgerald, who's from whanau, part of our panel law firm. Joe specialises in privacy matters and we're really happy to have you with us. We're thankful that we've got your expertise today, Joe.
Hi Sam, thanks for having me along, really appreciate it.
And along with Joe today we have Dr. Tim Cookson and Dr. Lucy Gibbard, who are medico-legal consultants and also GPs, as am I. Today's podcast is called Please Don't Tell My Mother, But I Told You, But What Do You Do with Unsolicited Health Information? I'm sure many of us have had a conversation with a well-meaning relative or friend of a patient that goes along the lines of, I don't want you to tell my mother I said anything, but they're a danger on the road and shouldn't be driving. Or it'd be something like, my daughter is coming to see you tomorrow about her warts. She's not eating and losing so much weight. I'm really worried about her. Please don't tell her I said anything. These are common issues clinicians face, particularly in primary care, but I'm sure that there are times where if you're a hospital clinician, that this scenario might also come up. And of course, as clinicians, we're very careful about not breaching the privacy of our patients. And these sorts of conversations can certainly leave us in a real quandary. So I'd like to talk about a few possible scenarios. So Tim, I'll ask you first. If a daughter of a patient comes to you and says that their parent is no longer safe to drive and not to tell the patient, how would you manage this?
Thanks, Sam. Well, look, before I started working at MPS and I was working as a GP, I would have happily said to the daughter, yeah, sure, I won't tell your mother, and we can sort this out, I'm sure. Working at MPS has changed my approach completely, and it's a case that I think Joe's going to talk about a bit later, involving this unsolicited health information that did definitely change my mind, because it was a very long and involved and challenging case, particularly for the poor GP who was involved, and I was very keen not to get into a similar position myself. So, yes, I certainly would not immediately promise the daughter that I wouldn't be able to say anything. And in fact, my approach after that was to right at the start say, look, this is important information. I mean, I would have tried not to get too much information, just that original bit, because the difficulty is that the more information you get, then is it information that you've received, and we'll talk about the meaning of that word received a bit later, and there are all kinds of implications as to what you need to do. So right at the outset, my approach would have been to say, look, this is pretty important, but it does put me in a really difficult position if you're saying to me, don't tell your mother that you told me, because if I start to act on the information, it's going to become pretty obvious usually that somebody's told me, and your mother's going to likely guess that it was you that told me rather than some stranger. So maybe you want to have a think before we go any further with this about whether you should actually say to your mother, look, I am worried about your driving. I'm not going to let my children go in the car with you anymore. So look, we do need to address this, Mum, and put it back on to the daughter. And then, if you've got the daughter's agreement to acknowledge where the information came from, then you're fine to proceed. However, that may not always happen. You may still get the daughter who said, no, look, my mother will kill me if she finds out. She's getting a bit angsty, and this is part of the concern. I definitely don't want you to say anything. So then you're in that really difficult situation because you can't guarantee anonymity. And if, for example, you do start taking some action and the mother says, well, how did you find out that my driving wasn't safe? Well, you can't lie. So that's an important thing. So you can't not reveal the information. And the other difficulty is, how do you actually act on it? So Rule 8 of the Health Information Privacy Code states that a health agency that holds health information must not use or disclose that information without taking any steps that are, in the circumstances, reasonable to ensure that the information is accurate, up to date, complete, relevant, and not misleading. So basically, if you're receiving this information, you've got to confirm that it's true before you record it in the notes and take any action on it. And that's where the difficulty lies with the mother. So you need to verify the information. Now, you might be able to contact another family member and say, your sister said that, so that contact the brother and say, your sister said that your mother's unsafe with the driving. Do you agree? And I'm not sure whether that breaches confidentiality or not. No, it's the sister's reporting. Joe might be able to tell us. Or you might go back to the sister and say, talk about it with your brothers and sisters. And if they agree, then, the information is therefore true, and I might be able to take some steps. And you might be able to say, as a family, we consider that to the mother that your driving's unsafe, and therefore, that gets around the problem of the anonymity question. But if I approached Joe, the brother who was a patient, and I knew him well as a patient, and said, this is the information I've received from your sister about your mother's driving, have I breached confidentiality?
It's a really, really good question, and it's going to be contextual. The extent to which you reveal things like that. You were revealing information about the sister at that point, aren't you, or the person who provided the information to you? That's what we call mixed information, I suppose. It's not just about the individual, but it's about someone's thoughts about this person's driving. There's been a lot of ink spilled on things like mixed information. When is information, health information about one person or the other? The main thing really is that you turn your mind to the consequences on both the parties involved. There is a basis under the Act to withhold information when it's requested, which would impinge on the privacy of another person. So look, it's always going to be contextual. It's always going to be a tricky question. The thing to ensure that you've done is that you've considered the impact on both the people. Ideally, you've documented that consideration so you can refer back to it later. And if you are saying, for example, I've received these concerns, the person asks, well, who tells you? That you're very, very clear with yourself that you're only withholding that information if you think you have a pretty good reason to. So look, it's always going to depend on the facts, and I don't think anyone will ever pretend that that's a straightforward decision to reach.
So I guess my safest step would be to say to the sister, is it okay if I talk with your brother about this and see if he shares your concerns?
Absolutely, yeah.
It does become a bit of a tangled web, though, doesn't it? If you're not allowed to talk to the mother. I have to say, I think my approach would be to keep it as simple as I could. And I think I'd say to the daughter at that point, if you aren't allowing me to talk to your mother about this or verify this information with your mother, there's only so much that I can, I really am very limited at what I can do. And then try very hard to explain to her how important my therapeutic relationship with her mother is. And then I don't want to lie to her, and we want us all to be honest, but equally her safety is equally my concern. So really, I really, really want your permission to talk to your mother about this, and I'll do it in a sensitive way. And, I'm not, I'll explain to your mother that you're only concerned about her safety. There are different ways of doing these things. I would hope I'd be able to talk the daughter around into allowing me to release that to her mother, because that's the best option for everyone, isn't it?
I guess the other question is there some other way that doesn't involve you of achieving the outcome that the daughter wants to achieve, which is to stop the mother from driving? And could they make an anonymous approach to Land Transport New Zealand to say, look, I've got concerns about X's driving, and is there any power within the NZTA to look into that? I don't know, actually.
I'm sure that there are other things that the family can do, like selling the car.
I think you definitely can report to the police and say someone's unsafe to drive, because I've had letters from the police saying we've had a notification about your patient who somebody thinks is unsafe to drive. So clearly people can notify to the police.
But can that be done anonymously? Because the daughter equally wouldn't want it to be known that she'd gone to the police. So
yeah, so if we think about the clinician in this position, from what I'm hearing from you both is that you can't guarantee anonymity
Of the reporter, yeah.
of the reporter, and it does need to be verified. And even if I was thinking that the son can verify, oh yeah, no, my mother's driving is terrible, you still need to see the patient about it. You cannot avoid that.
That's that tangled web thing.
That
I
is the
think really
tangled
that I don't think.
Yeah.
I think it's really true that that you need to be honest with your patients, and you should never say to that person who comes
No,
to you with
that's
information, "Oh yes, sure, I won't tell your mum." I think you just never give that guarantee, because you really are going to get yourself in a lot of trouble. These cases are so difficult sometimes, and we end up discussing them amongst ourselves as to what the right thing to do is. So I think if you're a clinician and you come across one of these scenarios, don't say, yes, I'll keep it secret, and then pick up the phone to MPS and get some help from some colleagues who've actually dealt with some of these cases before, because I do think that actually they are often very involved, and it's a balance of risks, isn't it? The privacy risks, but also the safety risks. And so I think you've really got to, and it often helps to talk that through with somebody else. So I think calling MPS is a good idea. I think that we often get asked about whether we write it in the notes, and often it's come in as a phone call and the nurse has written it in the notes, and you think, bother, because really you shouldn't be writing stuff in the notes until you've verified it. And if it's just a conversation and the daughter has said, no, I don't want you to release it, well, you don't want that information. You're rejecting that third-party information, and actually once it's written, you're pretty much stuck with it, and then you're stuck with dealing with the patient having a right to access to their notes. So I think being careful about what you write down, because as soon as you do that, it's very difficult to you shouldn't unwrite that.
Just in along that vein, if you have written something in the patient's notes, are clinicians obligated to advise the patient that those notes are sitting there? Because if the patient doesn't look or doesn't know to ask, they will never know. Joe, maybe I'll ask you.
Yeah, look, there's a legally answer to all of this. The long and short of it is that we, in the Privacy Act and the Health Information Privacy Code, the two pieces of legislation we're sort of primarily dealing with here, we talk about collection a lot. I think something Tim referred to earlier, when is something held, when is something collected, and when something's offered to you unsolicited, those elements of the Privacy Act and the Health Information Privacy Code don't actually apply. One of the things that the Privacy Act requires you do when you receive information is collect information, is explain to people what you're collecting, why you're collecting, what you're going to use it for, who you're going to give it to, all these sorts of things. It's why we have privacy notices on websites and all those sorts of things. If you receive information on an unsolicited basis, those provisions don't kick in. So actually what you're left with is information that you've recorded, but don't actually have strictly speaking under the Act, sort of a corresponding duty to provide information to the patient about what you've received. I mean, usually it's patients have a very good understanding of what you've collected because they were the ones who gave it to you. They were there present at the time. But strictly speaking, the Act doesn't kick in at that point. But I think what we've seen and what I've heard here today is that, practically speaking, you're going to wind up, if you have to verify under IPP 8, if you have to act on the information, it's going to be, in a practical, real sense, revealed to the patient that you've received that information. But I suppose the point from my perspective is just there's nothing sitting there in the Privacy Act saying, you need to call the patient and say, hey, I've just heard this about you. That obligation isn't there. And it's because, strictly speaking, when you receive things unsolicited, you're not deemed to have collected them.
Patient portals complicate this, because if your practice has a patient portal which allows patients to see the notes, then every time an entry is made, say, for example, by the nurse, then that person is going to be pinged to say there's been activity on your site, and they'll then go and look at what's recorded. So they're going to know about it instantly if the practice has a patient portal.
If we extrapolate that to a hospital scenario, lots of health information is recorded about patients, and the patients invariably never know about it unless it's made its way into a clinic letter, some kind of discharge letter that's gone to the GP. And often they copy in the patient at the same time. And I've never been aware that a hospital would say, well, this is what I've put in your notes. So if you extrapolate that out.
No, I don't think we do tell. I mean, we put so much in patients' notes without telling them all the time. But I think the thing is, you've just got to be cognizant that they can ask for it. So if it's going to be something that's going to cause a huge upset in 2 years' time when they suddenly realise that was written in their notes 2 years ago, I think you've just got to consider what is the best approach. And it's also about maintaining that therapeutic relationship, that if you've written something in those notes that they have a right to see, then actually, even if you aren't going to tell them it's there, one day they might find out, and it might be better to do that now and actually be open.
So there's probably a new Murphy's Law, isn't it? There, that the one piece of information that you don't want your patient to see is the one that they will see. So
Let's just segue now into a Human Rights Review Tribunal case that happened quite a number of years ago, which I think touches on this very thing of accidentally finding something out as in your notes. Jo, would you mind just maybe giving us a brief overview of the Human Rights Review Tribunal case, and we can just talk about it and the principles that we can learn from it?
Absolutely. And this is a case in the Human Rights Review Tribunal. So the main forum in which privacy concerns in particular are sort of litigated in New Zealand, not the only one. And the case Sam's referring to is called the Director of Human Rights Review Tribunals and QD. It was a case, the decision was released in 2010, and it concerns a complaint against a doctor. The complainant in this case was a woman, and it concerned information disclosed by her husband to the GP. They shared the same doctor, and what the husband disclosed to the GP was that he was concerned with his wife's mental health, and also some documentation that he had obtained. The wife discovered this disclosure by chance, one of these things that just happens, whereby she was in the clinic at the time and saw something on a screen which alerted her to the fact that this information had been received. And the individual asked for access to this information. The husband, at the time he provided it, had asked that the doctor receive this in confidence, that he keep it in confidence, and he agreed to this. He agreed that he would retain the information and not provide it to the wife. And when the wife subsequently asked for copies of it, asked to receive this information, given it's information about her, she's entitled to request access to it, the doctor refused. And this was the battleground, if you will, of this case, a situation in which information was received from the husband. The doctor agreed that he would hold it in confidence, that he wouldn't share it. The wife subsequently finds out and then asks for copies of it. And I'd be very interested in everyone else's views, but perhaps before we dive into those, I did take the time just to note down some of the Human Rights Review Tribunal's comments, because sufficient to say they weren't overly impressed with the doctor in this case. The doctor had throughout this process steadfastly refused to provide the information to the wife, and there are circumstances in which you can refuse to disclose information where disclosure would pose a threat to life, where there's a prejudice to the health of the individual concerned, where it results in the unwarranted disclosure of affairs of another. But the Human Rights Review Tribunal was very comfortable that none of these applied. And just to maybe expand on that, they had a heading in their decision called Some Observations, under which they said some of the following comments. We do not have a great deal of sympathy for the defendant on these points. The underlying problem was created when the defendant agreed to accept personal information about the complainant on a promise of confidentiality. We were surprised that the defendant considered there was an entirely appropriate basis for him to receive the documents and give A the assurances he wanted. So I suppose it's just a case of being very careful. And again, I'd be interested in others' views, but the problem here was created at the very start when the doctor accepted information from an individual about someone else and made that promise to not take it any further. And as we've seen in the decision, the tribunal was very critical of that.
That comes back to the kind of things we were discussing right at the beginning, wasn't it, about addressing that question of, can I keep that secret? And promising anonymity. And I remember this case went on for a long, long time, and MPS was involved at a lot of different stages. And I think at one stage, even before it got to the HRRT, that there was a suggestion that a basket of nice goodies might be some way of resolving the conflict between them. But clearly that didn't happen.
I suppose what I would add, I mean, it's one of those situations where it might be that when the person eventually asks for copies of the information, you do decide, in the fullness of time, actually I've reviewed it and I have a ground to withhold it. But it just emphasises that you can't make that decision at the start. You've got to inform the individual that you can't promise their anonymity. And it seems like here what's happened is the doctor, made that call at the very beginning, then later on didn't realise, as it would seem, there wasn't a basis to continue to withhold it, but had pinned themselves into a corner. And as you say, if you find yourself in a position where you're suggesting that maybe a basket of goodies is the answer, you're probably on the wrong side of things, I imagine.
Yes, and the essence was that the husband, the doctor felt that his relationship with the husband and that breaching his promise to keep it anonymous, to not reveal, was more important than the provisions of the Privacy Act. But clearly the HRRT did not agree with that position.
I think the prime consideration is who's the patient here, because your duty of care is to the patient, who's in this case was the wife. I mean, of course, the husband was a patient as well, but the information related to the wife. And so I guess for clinicians, it's about who's your patient in front of you right now, and that's where your duty of care lies. And that might have helped the GP in this particular instance.
And as always, it was complicated because the husband, I think, concerns supposedly were around the safety of his children with the wife, because they'd split up by the stage. And so the children came into it, and there were all kinds of, complicating factors.
What if they'd put that information in the husband's file and it was about the wife and the wife became aware of it, but it was never in her file?
Well, she wouldn't have become aware of it, is the first thing. Well, she ought not to.
Ought not to.
And the problem was here that there was an entry made in the wife's file about this information being there. And that's how she found out, I understand.
But I think it doesn't matter where you keep it, does it? Because actually it still remains the patient's health information. If they become aware of it by whatever means, I mean, yes, surely you're going to say she's going to be less likely to be aware of it, but it doesn't matter where you hold it, does it, if it relates to that patient?
Absolutely. Look, if someone makes a request under the IPP 6, which is the relevant rule here, or Rule 6, for all of their information, doesn't matter where it's kept. I suppose what it does indicate is that actually this, we spoke about mixed information before, it does contain something about the husband. It contains something about the husband's concerns. That is information about him. It's information about what matters to him and what he's thinking about. So it does raise a slight complicating factor, doesn't it, in terms of what do you actually reveal to the patient if a request is made, because it's not necessarily everything that they were told. But yeah, absolutely. I mean, having something on one file as opposed to another isn't necessarily sort of a panacea in these situations.
Very interesting case, that one. So let's turn our mind to a slightly more complicated scenario than the driver's license one. So, Tim, I'm going to ask this of you. A wife calls up and is very anxious about her husband, who has been depressed and having outbursts of anger. She's becoming increasingly scared for her safety and that of her children. She wants you, the doctor, to help her, but please don't let her husband know that she's spoken to you, because he might take it out on her. How would you manage this, or would you manage this any differently from the previous scenario?
Yeah, I think I would manage it differently, because you've actually got a whole lot of people with potential problems here. So you've got the husband who it sounds like hasn't been in to see you and his depression hasn't been addressed, but he may be at significant risk. But then you've got the problem that the wife is probably quite right, realistically said that if it's found out that it's her that's released that information to you, that her life or health could be endangered because of his anger outbursts. So this is, I agree, much more complicated than the driving one. And I think the first thing to tease out would be the wife's situation. How vulnerable is she? And to find out a bit more about, well, these anger outbursts, what has happened as a result of those? And does she actually need to be advised that she needs to go somewhere where she is safe? Because whether or not the information is revealed to her, she could still be really at risk of harm coming to her from the husband's anger. And of course, if it was at that stage and she did go somewhere where she was safe, then it would be easier to act on that information with the husband because you knew that there would be no repercussions for the wife in that situation. You'd probably want to tease out just how bad the husband's depression was and, what are the risks to him from his depression? Is he likely to self-harm? Does he have guns in the house? And that's something that would then need to be thought about whether you notify the police about that risk, even though it's secondhand information, but that's still important enough that you would need to think about whether you have an obligation to report to the police. But again, then if you do that and the police act and the husband realizes, well, it must be my wife who's given that information, then the same risks come back to the wife again. So those are the dilemmas. But I don't think you have the choice in this scenario to say, I'm not going to do anything about it, because the information that you've been provided with is so significant for more than one person. I would seek advice.
I'd seek advice, yeah. Ring in for you. I was thinking about this with oranga tamariki as well, actually, because there are some safety guards when you're reporting to oranga tamariki, aren't there? So, and if there are children involved and they're at risk, actually that can be a way of trying to ensure safety.
But would that prevent the husband from coming to the conclusion that it was his wife who'd revealed the information and therefore that same concern for her well-being?
Yeah. Hard to say, isn't it? It's all these things are hard to say, but I do think you really want to make sure that you've made sure that the wife and children are safe before you actually address the issue, because you don't want to make things worse, do you?
Mm-hmm. And the other thought that came to mind was, is the information that you have received from the wife indicate that the husband's depression is so severe that you could invoke the Mental Health Act and get him compulsorily assessed.
So when we're talking about unsolicited health information and privacy, really it comes down to the specific situation, because there are lots of different approaches or lots of things that the clinician needs to think about, not just the privacy concern. I think that's what I'm hearing from you all. And I guess also the greater the risk to the patient or other individuals, the greater our need to act. Is that what I'm hearing from you guys?
Mm-hmm.
Yeah. And seeking advice and thinking about avenues and the safest way of doing things.
Yes.
Because wading in there isn't always the right thing to do either. Often a measured approach and looking at what avenues you can use and what other resources you can use can sometimes actually make it work out.
So what would you say to the wife? She said to you, please don't tell my husband because it's going to put me at risk. But we need to act. So therefore it's almost impossible to say to the wife, you can say, I won't tell your husband that it was you. And I think that the Privacy Commissioner has placed information on his website or her website to say that if there is a significant risk in a relationship to another person, that you can withhold it. But in this situation, it's very likely that the husband is going to know the source of the information. So it is about protecting all parties involved, but acting in the patient's best interests as well. Do you have anything to add to that, Joe?
No, other than just that's exactly right. The the Privacy Act and the Health Information Privacy Code are very much not here to inhibit people from either making the disclosures or withholding the information they need to withhold to keep people safe. There are very clear provisions in the Act itself around when you can disclose information or when you can withhold the particular piece of information because there's a serious threat to someone. So in this situation, I mean, this is almost the more extreme example that allows you to demonstrate that rule. But as you say, while the legislation might clear a path for you to either provide the information you need to or withhold the information you need to, I suppose the other consideration, Sam, and it's more a practical clinical one as well, that to one side, what are your actions going to reveal? You might not necessarily name the individual to the husband, but if you are compelled to take steps here, what is that going to mean the husband can imply or will assume, and what do you need to do to ensure people stay safe in those circumstances?
Let's look at one final scenario. There are 3 people who are flatmates and all are registered with one doctor at a practice. Not uncommon for each of these patients to talk about their flatmates during the consults. The doctor does not enter into a discussion about the other patients or flatmates that they have when this is brought up, but of course still holds that knowledge. So let's just say that one of the patients come to see the GP and was complaining about the behaviour of her 2 flatmates, always interfering in her affairs. The flatmates had barged in the day before whilst she was having a drink in her bedroom. The GP then asked the patient if she thought perhaps the flatmates were concerned about her drinking. And there was arguably perhaps some context to this from the immediate discussion with the patient, but it was very likely that the comment from the GP is prompted by the background information the GP has received about the patient's habit from their other patients. The patient has made a complaint that her privacy has been breached to the lead GP and is convinced that the enrolled GP has discussed her with her flatmates. So in this particular scenario, Lucy, do you think that there's been a breach of privacy?
Well, you're allowed to receive information from the flatmates. And, we often say that, it's fine for you to tell me things. I'm limited about what I can tell you. And clearly they're the patients too. So you can't restrict that. So, and it's very hard to unknow things as well. It depends is the answer. I think on the whole, if it was within the context of the conversation and actually the question was a genuine one, I don't think there has been a privacy breach here. But you can see why the patient is concerned that there might be. And I think we often do get this situation in families often where you have, because it's very common for GPs to have multiple members of the same family, and when there's family conflict to hear about it from everybody. And we definitely have advised some of our members in the past in these situations that actually sometimes it's better just to say, I can't look after all of you, particularly when there's a husband and wife in an acrimonious relationship breakdown, and you're hearing it from both sides. Actually, you're in an impossible situation. Because you can't unhear it. And it's very hard to say, well, I'm not thinking about that when I'm with you, because you know it, or you've been told it by somebody else. So I think that really in this situation, there probably wasn't a breach. Having said that, I think the wisest thing for that GP to do is to say, if I find myself in this conflict situation, actually I can't be the GP to all these people who are telling me about each other, because it provides an unsafe environment for a risk that I will be perceived to have done that. I have to say a case that I had where a GP was a GP to an employee and an employer who both came with the same issue, and again you're in an impossible situation. So I think the best thing for the GP is to say, well, I can't be GP for both. I don't know. How do you think about that? What do you think about that, Tim?
Well, one of the problems that appeared with this, with the complaint is actually it's going to be very difficult for the GP to prove that they didn't have a discussion with any of the flatmates. So it is an accusation that is going to put this GP in a very difficult position, because they can say, no, look, I didn't, but that may not convince the flatmate. And if, particularly if her drinking is something that she feels guilty about, she's much more likely to actually pursue it further, ironically, and complain further. So I think you're right. But in this situation, the GP may not have been aware that they were dealing with people in conflict until they actually got that information right at the end. So may not have had the chance to take your good advice to start separating them out and farming some of them off to other people in the practice.
I think that's a fantastic recommendation, actually. And if you can, I understand, and you make the very good point that it's going to be hard to identify those situations potentially until it's too late, because the conflict is there at the point in time you realise you have to separate people out. But it's definitely a fantastic recommendation if you can reach that decision point. I suppose the other thing is just, to me, I mean, to what extent is the GP in this situation actually sort of following through on their obligation to verify information to ensure its accuracy before they act on it? I mean, they've raised this, they've received this information, haven't necessarily collected it, and then it's come up in a consult, presumably because they're trying to figure out whether this is actually the case or not before they do anything further. And I've definitely been involved advising on cases like this where on one view of it, people are exposing themselves to, well, maybe exposing themselves to criticism, more putting themselves in the firing line by raising information again. But on the other hand, under IPP8, you've got to make sure things are correct before you do anything further. And so it's a slight catch-22. I don't think there's been a privacy breach here, and I think actually you could say that the GP is doing what they need to do to comply with their privacy obligations, even though your patient at the end of the day might not view it that way.
And I guess good clinical practice would have dictated that the GP ought to have asked questions early on, before any of this came up, about this person's drinking habits. Now, they may not, of course, been told about how much they were drinking, but if the patient had been honest and said, look, I do have a bottle of wine a night, then actually that's the information that they could then use to link things together and make it less likely that the patient themselves is going to assume that it's the flatmates that have been the source of it, the information.
It's clear that clinicians often face privacy dilemmas, and they're not always straightforward to sort out, and do require some thought, don't they?
Well, and speaking of getting advice, it's also when these difficult ones come into us as advisors at MPS, this is the kind of conversation that we would then be talking with someone like Joe about, to get extra information, just because of the complexities of the Privacy Act and the nuances that need to be considered.
Yes. So for our listeners, perhaps some take-home messages. Lucy, what would you say are some take-home messages from today's podcast?
I think stop and think is probably the first thing, that when someone's talking to you, actually, first of all, think, oh, am I receiving information here? Is it about the person who's giving it to me? Is this third-party information? So I think even just being aware of it, because so often it's a normal part of family practice that you receive information from lots of sources. So I think an awareness that you're receiving third-party information is the very, very first part. That other huge thing is never, or not never, there's never and ever in medicine, is there? But being very careful about guaranteeing anonymity from the person who's giving you that information. You really want to make sure that actually you've thought about whether or not you are going to be able to do that, because it puts you in a terrible position if you said, yes, I'll keep you anonymous, and then you later find that the Privacy Act says you can't. So I think be very careful about that. And before you do that, seek advice. Then there's that issue about verifying information when you've heard something that, if it hasn't come from the patient, that you do have that obligation to verify it. And normally that would be by going back to the patient and asking them about it. But then, of course, that whole issue becomes the patient. The first thing the patient asks you is, why are you asking me this? So that's why we don't want to guarantee that anonymity at the beginning. And obviously patients do have the right to see what's in their notes, and there are withholding grounds that Joe's told us about, that there are times when we won't give or we will advise that patients shouldn't be provided with the information in their notes. But it's a pretty high bar, and generally patients should be given what's in their notes, and you've got to have some serious concerns if you're withholding information. And then the last one, do you need to write that information down? Do you need it in your head? And that actually, that's another whole question of itself, really, isn't it? As soon as you write things down and they're in the notes, you can't just take them out. So you've got to be really careful about what you write down. But equally, if it's in your head, you're still holding that information. So, in itself, that's not a very easy thing either. Don't know. What do you think, Tim?
Well, one of the other things to think about too is we will all make mistakes regarding privacy. And so if you have made the mistake at the beginning and said, yeah, no, sure, I'll keep that secret, but then it becomes apparent that promise is a problem, you better early on to say to the person that you've made the promise to, look, I'm really sorry. I made a mistake when I promised to keep this anonymous, because actually I realise now that I don't have that right to do that. And so these are the consequences, and this is what we'll need to do. And I think if our gentleman in the HRRT case had done that relatively early on, rather than digging the hole deeper and deeper, it would not have gone to the HRRT, would be my guess.
And probably the last word would be to say that privacy is a minefield. It's not that straightforward. You can read all the rules in the Health Information Privacy Code and think, oh yeah, I've got that. But the reality is every case is nuanced, and it really does depend on the specifics of your situation as to what advice we would give. So we would encourage you to call your indemnifier if you are uncertain, because once information has been released, it can't come back very easily, and it has big implications for clinicians and patients.
And Joe has emphasised previously as well the importance that if you do have an issue that clearly involves privacy and you're making decisions around whether or not to release information or whatever it might be, that actually recording the reasons for your decision at that time is really, really important, because if it does go to the Privacy Commissioner, that's what they'll be looking for, is evidence of your thinking about the issue, as opposed to a complete blank and, oh, did I think about it?
Not sure if I did. Well, thank you, Lucy, Tim and Joe, for all your great input into this podcast. And thank you for those who are listening to this podcast. We hope it's been really helpful for you. And we look forward to catching up with you in our next podcast. If you like the Medical Protection Podcast, please subscribe and leave a review. And if you would like a podcast on a specific topic, please do feel free to email us on nzpodcasts@medicalprotection.org. We'll catch you up next time.